Hello, welcome to our webinar today. We're Contact, the charity for families with disabled children and children with additional needs of any kind, with and without diagnosis, and from the ages of 0 to 25. We hope you enjoy the webinar today and find it informative. If you need any support afterwards, please do not hesitate to get in touch with us.
So, good morning, everyone. Lovely to see so many people on the call. By way of introduction, I am a solicitor with Irwin Mitchell. I've been dealing with trusts and wills for about 18 years now, which makes me feel really quite old. I specialise very much in helping families with vulnerable children who may have different needs, whether that's learning difficulties, mental incapacity, and so forth. My job very much is to provide peace of mind, really, to families, so they know the right legal mechanisms are in place, so that when you're not around, you're not able to care for your child, there is someone there, there is a structure there that enables them to have the best life they can after you've gone. So my rather depressing talk today is about wills and trusts. I will say that trusts have been around since the Crusades. So I could talk on this topic for a very, very long time, but it would be rather dry if I did so. So I'm going to try and boil it down today to two aspects, really, talking about wills, why they're so important, what having a will really provides. It's really about authority, certainty, flexibility. I'm going to talk about a little bit about tax on estates. Inheritance tax is a big subject on its own, but I will touch on it just to give you some flavour of how having a proper will in place can really help with that side of it. And I'm going to do some myth busting as well. There is a man down the pub who tells people a lot of wonderful legal advice, and most of it is complete rubbish. So I want to try and get you away from that man in the pub, try and help you spot those myths which have been around for so long. The other half of this talk is going to be about trusts. What are they? How do they work? Do you need one? If you've got one, how can you run it properly? And again, touching on tax aspects of trusts. They are not the panacea that everyone thinks they might be. They do come with some downsides as well. So I'm going to talk very much through the pros and cons of trusts, both under your will and setting them up in your lifetime. And then I'm going to round off with a case study that hopefully will bring this to life. I appreciate there's going to be a lot of information in this talk, and much of it might be quite complicated, but hopefully the case study will really bring it to life. As Kate said, do feel free to post questions in the chat as we go through. I'll try and keep an eye on those. If you're thinking, if you've got a question, I can guarantee there'll be 6 or 7 other people thinking, oh yeah, actually I've got the same issue. There are no such things as stupid questions. Believe me, I've heard it all during my life, and I've never encountered a stupid question. I've attended a few seminars where there've been stupid answers, but that's the job of the presenter. Anyway, moving on. So wills, let's start by talking about why they're important, what they can and what they can't do. A lot of people, think of wills, either as a last minute thought. Literally, in some cases, I have dealt with some deathbed wills where people have, not got their affairs in order, and I'm literally by the bedside preparing a will. They are really important. I think the best way to look at a will is it is your last word on this planet. And really importantly, you're setting out under your will who is going to deal with your estate, who's going to deal with your assets after you've gone. Even more importantly, who's looking after your infant children. You're going to want to put people in place you trust to make sure they get the right upbringing. You can set out your wishes about what kind of life you want them to have, who you want them to associate with, what kind of education you might want them to have, what aspirations you have for them. And all those things you can set out to your guardians. Setting out your funeral wishes. Some people go into a lot of detail. I had one client who's set aside quite a lot of money to be set off in a firework when she's gone. Each to their own is all I can say. As you know, you can leave legacies of cash or specific assets under your will as well. But important, and this is the thing I'm going to talk about a lot today, is the idea of setting up a trust under your will. And this is where it really can help provide a secure future for your children. Things you can't do under your will, though. You can't appoint attorneys. You can't appoint a deputy or someone to take decisions for your children or for beneficiaries under your will. You can't direct what happens to assets that aren't part of your estate. So if you have a pension plan or death in service benefit or maybe life insurance, that may not pass under your will. I'll talk more about this in due course, but it's always worth looking very carefully at what do you actually own in terms of assets that go under your will. And you can't use your will to stop someone bringing a claim on your estate. You construct your will to minimize the chances, but you can't stop someone from potentially bringing a claim. And this is a question I get asked a lot, is how do I make my will so X can't claim? You can't. So let's start with the three things I was talking about: authority, certainty, and flexibility. Authority is probably one of the key things that's important to think about under a will. Where you have a valid will in place, the people you appoint as your executors can start acting from the moment of your death. They have the right to do so. You've named them as the executors. They're allowed to act. They don't necessarily need to have to wait for a grant of probate to deal with your estate. And another question I get asked is, what is a grant? Why is it needed? And very briefly, a grant of probate is the court sealed document, the court approval that the people who claim they are the executors of the will are indeed the right people. This is your last will. They are the right people to deal with your estate. And the grant may be needed to sell a property, to close bank accounts, to deal with various assets. It's the reassurance to the bank, to the financial advisor, whoever it might be, is these are the right people, these are the right executors. There are things the executors do before getting the grant. So they can arrange the funeral, they can give out personal belongings, they can start the correspondence with the bank. And in some cases, depending how much is in an account, a bank would be quite happy to close it and hand the money over to them even without sight of a grant of probate. And they can also put a house on the market. They can't sell the house until they get the grant through, but they can start marketing it. So it's really important, from the moment of death, the executor can start work. As I said, well, guardians, you can appoint guardians under your will who take over parental responsibility for minor children under 18. And I'll emphasize that the guardian's role is for children under the age of 18. They don't become guardians for children over the 18 who might lack mental capacity. The guardian only acts for a minor. The second thing about the will is it's certain. You know who's dealing with your estate. You know your executors are distributing your personal items. You know who's talking to the banks. You know who's dealing with your funeral. You know who's looking after your children. It makes sure there are no surprises. And a very, very sound bit of advice there was from one of our older senior partners many years ago. And he always said to clients, never let your will be a surprise. It's much easier to have conversations in your lifetime with your children about who's getting what than after you've died, really. The point is, if you are going to split your estate unequally, or if there's someone you're going to write out, or if you're going to do something which someone might turn around and say, that's a bit unfair, talk about it in advance. It may not be a pleasant conversation to have, but say it's much easier to do it to seek out those potential disagreements during your lifetime, and they're making a will that's hopefully not going to be disputed in the future. So you can't stop disputes with your will, but you can help to avoid them. And finally, flexibility. Most people think a will is absolutely set in stone, that perhaps it's illuminated by monks and there it is, that's the parchment and it's there, you can't change it. After your will says Bob gets £20,000, Alice gets this. But your will can be really, really flexible. And this is where protecting assets for children or for other family members really comes into fruition. And that's by using a trust under your will. So rather than giving assets outright to children, to other family members, saying you get this, you get this, you get this, you can put it into a trust and say to your executors, look, this is what I'd like to, But I leave it to you to decide who gets what and how much. And that's really, really important, particularly with vulnerable children. If they are unable to take financial decisions, or we think maybe they are probably going to be okay in the future, but you think actually they're going to be not necessarily financially mature. I mean, I look at my son, whose plan is to become a YouTuber and play Minecraft the rest of his life and live off Big Macs. I mean, he's not someone I think I want to have a lot of money at a young age. And by using a trust structure, you can say to executors that see how he is at 21, 25, 30 even, and maybe give him an income from my estate, but don't give him the capital assets outright. Otherwise, he will just blow them on something ridiculous. So a trust structure is really useful like that. I'm going to talk in a lot more detail as we go on about how it works in practice. The other thing a trust can do is mitigate inheritance tax. I'm going to touch on inheritance tax in a bit more detail, but effectively the current rates of inheritance tax are 40% of your estate disappears to the government of the value over £325,000. That's the starting point. If you own a property which has been your residence at some point during your lifetime, if you give that to direct descendants, so that's children, grandchildren, and so on down, you get an additional allowance of £175,000. And married couples can transfer those allowances. So if you don't use the allowance, if you don't use your no rate band on the first death, it can be transferred and used on the second death. So basically, between a married couple, you can leave up to £1 million tax-free to the next generation. So that's your allowances of 325 each, plus your residence no rate band, £175,000 each. Total that up, it's £1 million. And also your will can just adapt to circumstances at the date of death. If your views have changed during your lifetime, or people are getting divorced or so forth, this flexibility under the will can ensure assets are protected for the long term. So what if you don't have a will? Well, it's sort of the opposite of what I've just said. There isn't any authority. You don't have anyone immediately from the date of death who's allowed to act. There's this wonderful myth of next of kin. It doesn't exist in the law. Next of kin isn't something that exists. There's the principle of people who are allowed to inherit under intestacy, where someone doesn't have a will, and they can apply for a grant of administration. It's like a grant of probate, but it's a grant where there's no will. But they have to go out and get that before they have any authority to act in the estate. And if you've got someone who thinks, oh, I'm the next in line, I'm the next of kin, and they go off and start trying to close bank accounts or arranging funerals or things like that. But actually, it turns out they're not the person entitled to the grant on intestacy. They're personally liable for the expenses they've incurred. They may find themselves with a £5,000 funeral bill that they're not entitled to recoup from the estate. They weren't allowed. They weren't the right person to do the job. If you haven't appointed guardians under your will, then someone else has to apply for parental responsibility. So you're really leaving minors at risk of not knowing who's going to be looking after them in the future. Uncertainty, the distribution of your estate is going to be governed by statute. And one of the myths I talk about later is this principle where people think, well, I'm married, everything goes to my wife. Maybe not. It all depends on how you own the assets, the value of the estate, whether or not you have children, and so on. So, setting it out in the will makes it really clear. You know where your assets are going. Who's going to look after assets for a disabled child? If you don't have a will, that child is entitled to those assets at age 18. And if they're on means-tested benefits, they've gone. If they receive more than £6,000 or £12,000, those benefits are lost until they've spent that inheritance. So it's really important to look at structural will properly for a disabled child. And there's no flexibility at all. Say if you haven't got a will, assets pass outright to beneficiaries. If one of those beneficiaries is getting divorced or is declared bankrupt, those assets can disappear, their inheritance can disappear in funding that bankruptcy, funding that divorce. As I said before, state benefits, they can be lost. Minor children inherited age 18. So with my son, that would be an absolute disaster. And you may end up with unnecessary inheritance tax as well. If you're looking at an estate worth more than £500,000, or you don't have a residence that's worth more than 325, if it's not passing to the spouse, you may not be making proper use of your nil rate allowances. So really, really important to have a will in place to make sure your estate is protected in the long run. You know what's happening. I said I'd talk about inheritance tax. I'm going to try and keep it brief. It is a complicated area. It's been messed about with by governments over so many years that they keep sort of adding little bits to the rules. But let's say that the basic principle, the headline rate of inheritance tax is 40%. It's not just on what you own at the date of death. It applies to any gifts you've made in the last 7 years. So if you've given away, £100,000 or whatever to a child or something, that's added back into your estate if you die within 7 years of that gift. From next year, the value of your pension fund is going to be added in to the estate as well. And this is catching a lot of my clients out, causing a lot of concern. They're thinking, wait, I've got my property, I've got my savings, I'm well under the £1 million allowance. That's fantastic. But if you throw in a pension fund that might be worth £250,000, £300,000 maybe, you're suddenly over that limit and paying inheritance tax when you weren't expecting to previously. We wait to see how inheritance tax on pension funds is going to work in practice. There are a lot of practical implications, and members of my firm involved in the discussions with government consultation saying, it's not going to work for various reasons. And we're hoping pension companies will cooperate and work well with executors to make sure actually it can be administered properly. But the government's not back down. The headline, the rules that are coming in April next year, pensions will be part of the inheritance tax net. Anything you leave to a spouse or charity is exempt from inheritance tax. Now, that's where you've got to be thinking about bunching assets in the survivor's estate. So, if you're leaving everything to the surviving spouse, no tax on the first death, but have you pushed their estate over the £1 million, and suddenly are they suffering inheritance tax on their death? So again, structuring your will properly can help reduce tax by maybe passing assets down to children on the first death. There's no additional exemption for assets passing to a disabled or vulnerable child. Ironically, the people who need it most don't get an additional benefit. If assets are passing to a child, it will come out of your nil rate band, or it will come out of your residence nil rate band. So it's something I've felt is very unfair over the years, that there isn't an allowance for children who could benefit from not having inheritance taken away. But that's the situation. Only assets passing to charity or spouse are exempt. Anyone else, you're looking at tax over that nil rate band allowance. As I say, between spouses, you get your 325, you get your 175 if you've got a residence. If you don't use it on the first death, so you can pass everything to the surviving spouse, those nil rate bands are unused, can be used on the second death. But you've got to be a little bit careful. So if you've got a valuable estate and you're going over £2 million, then you start losing your residential nil rate band. So for every pound your estate exceeds £2 million, you lose for every £2 your estate exceeds £2 million, you lose a pound of the residential nil rate band, which means estates of 2.7 million, no residence nil rate band at all. Let's say in total, a married couple can leave £1 million tax-free to children. If you're unmarried, you've really got to think about this carefully, because assets passing to a common law spouse, a partner, are not exempt from inheritance tax. And what you can find is, let's say you leave a £600,000 estate to the surviving spouse, everything on that over 325 is going to be taxed at 40%. It then passes down to the next generation, to the children. You're going to get the surviving spouse's nil rate band, 325. You might get their residence nil rate band of 175, but you're not going to be able to transfer anything from the first to die because they're unmarried. So really important, particularly if you're unmarried, to think, how's my will going to work? How's inheritance tax going to hit? And say, £500,000 is quite a generous figure, maybe looking at your estate, but then start throwing the pension pot and everything else in it like that. Suddenly you can find yourself easily exceeding that £500,000 allowance. Jumping on to myth busting. Well, there are so many things I hear from people that I like to try and correct as I go along. So one thing people say, you don't need a will, you're married, so your spouse will get everything. not necessarily. The intestacy rules provide a statutory legacy to the spouse, a set amount that they are entitled to have. Everything else is split equally between the spouse and the children, who get it at age 18. If there aren't children, then it may, and you're unmarried, as I say, you won't, it won't automatically pass the unmarried spouse. So as I say, that third point there, your partner is your, sorry, there's a typo there. Partner's my common law spouse. That'd be very odd. Sorry, your partner is your common law spouse. They will get everything. No, common law spouse does not exist in law. It's not something that someone can say, I've been living with them for 2 years. I'm entitled to the estate. A common law spouse, an unmarried partner, has a right to bring a claim against the deceased's estate, which is very different to saying they are entitled to assets. And I've dealt with some difficult cases over the past. There was a situation where a chap had been living with his partner for many years, no children, and under intestacy, he didn't have a will, under intestacy, everything passed to his sister. Funnily enough, the sister didn't get on with the partner. So there was this huge, long-winded legal battle over what the partner was entitled to, and it cost a lot. It was battled through the courts, and at the end of the day, there were no real winners out of it. So, in that situation, if he had had a will, he could, given his partner the right to live in the property, or given everything to her outright, and the sister wouldn't have come in, wouldn't have necessarily had a claim. Jumping back up one, you own everything jointly. So your estate passes automatically to a spouse. Well, not necessarily. It very much depends on how you own joint assets. So there's 2 ways of owning assets jointly. There's what's called joint tenants or tenants in common. Joint tenants, most bank accounts, or all bank accounts really, are joint tenancy. So if you have a joint bank account, it will pass to the survivor, regardless of whether you have a will or not. Tenancy in common, and you'll find if you own a property jointly, very often you'll say, actually, I want to own it as tenants in common. The default is joint tenants, but if you opt for tenancy in common, you have a share of that house, and it will pass under intestacy, or it will pass on your will. It won't necessarily automatically pass to your partner or your spouse, whoever you own the property with jointly. Another thing is, well, I've already got a will, don't need a new one. Or maybe you do. If you've got married after you made your will, it revokes your will, which I find very ironic, because divorce doesn't revoke a will. Divorce simply treats the ex-spouse as having died at the date of the divorce, which some people might quite like. But this is the point. It doesn't revoke, that divorce doesn't revoke the will. And if you've got divorced, you may really want to be coming back and looking and going, well, actually, is it still right? And so if you've got married, you no longer have a will. You're looking at intestacy then. And particularly where you want to provide for disabled children, really important to review the terms of your will on marriage. If any of the beneficiaries die, look at the will again, make sure it's still doing what you want it to. Is there a substitute provision? So if you leave assets to a beneficiary and they've died, is there a substitute to step into their shoes? If not, that part of your estate may well be intestate. And does your will deal with all your assets, as I've talked about, sort of pension schemes and things like that, and the fact they don't pass under the will? Kate, I see you've got your hand up. Did you have a question you wanted to raise?
Yes, Stuart, there's one question in the chat that applies to the residence nil rate.
Yes. So, would the residence nil rate ban apply if your will leaves your home to an existing trust in favour of a disabled child, as opposed to leaving the home directly to the child? It depends on the terms of the trust. I'll talk about this in a little bit, but if you are leaving your property to what we call a life interest trust, where the child has the right to live in that property from the moment of death, or you're leaving it into what's called a disabled person's interest trust, then yes, the residence nil rate ban will apply. If you're leaving the property into a discretionary trust, where the child doesn't have a right to the property, and it's not a discretionary disabled person's trust, no, the residence nil rate ban will not apply. Another reason to dig out the will and just double check those terms, make sure they are right for your circumstances. A bit more myth busting. Everything passes under your will, as I've touched on before. No. Pension funds, life insurance, death in service, trust interests, may not pass under your will. Depends on how they've been nominated and any other instructions that have been given to the pension provider, the life insurance company, or your death and service provider. So, when you're looking at death planning, or as we've termed it, dying tidily, don't only think about your will, think about nominations you've made to the pension company. Very often when you set up a pension, you'll be given a letter of wishes, a nomination form, and you go, I'll fill that out later, or I'll give it all to my spouse, whatever. If you've separated, got divorced, something like that, dig that nomination form out, for goodness sake. Make sure actually it still does what you want it to, because where you haven't made a nomination, the pension company will often say, right, what are the terms of the will? Who are the family members? And they've usually got discretion to decide where they give to whom they give the pension fund. I had a difficult case some years ago where my client had a son was addicted to drugs. Very, very sad situation. He said, look, I don't want him to get anything. So we put a discretionary trust on the will. Nothing was going outright to him. And I said, you must notify your pension company as well. Tell them you don't want him to get assets outright. You want it to pass into this other pilot trust, this lifetime trust that you've set up. For whatever reason, the pension company didn't process his nomination to a certain extent, but they didn't process it properly. And after death, they said, oh, well, sorry, no, we didn't see this nomination in his lifetime. We have no option but to pay it to the son. We got involved and looked at the pension scheme rules and said, well, actually, you do have discretion. Look, you just got to look at the pension fund rules. But they stood firm and said, no, we are not going to exercise that discretion. We're going to pay it to him outright. We said, it will be a disaster if you do. Thankfully, it was at a time that the son was in rehab, and we convinced him to put the money into a property rather than having it as liquid cash. So we were able to kind of protect in that way. But it just shows it's so important to make sure the right nominations are in place with the life insurance company, with the pension company, and make sure they've processed it, make sure it's up to date on their system as well. Another myth I hear, is a will can be changed after death. So what's the point in making one? Yes, people can do a deed of variation or a deed of family arrangement to kind of redirect assets. I hate the term that a deed of variation rewrites a will. It doesn't rewrite a will. It's only effective for tax purposes. So basically, if I receive some money under a will and I say, actually, I want to give it to my son, I can sign a deed of variation to say it bypasses me and goes directly to him. It's still a gift from me, but the revenue treats it as if it was a gift from my parents. If I am in receipt of welfare benefits or something, and I make that gift, I make that deed of variation and pass the money down to my son, the DWP are going to turn around and say, that's a gift by you. That's depriving yourself of capital. Therefore, we're going to take away your benefits. We're going to treat you as still having that money that you've given to your son. It doesn't rewrite the will. It's a gift by you, but for tax purposes, it's treated as if the deceased's will had done it. So yeah, don't rely on being able to change things after death. That's what I'm going to say on wills for the moment. I'm going to move on to trusts. We're about halfway through, so probably a good time to move on to trusts. There's a question on does Free Wills Month, March and October, only apply to those 55 years or over? I'm not sure. I've not engaged in Free Wills Month myself. It may be something that one can Google an answer to, but what I will do is certainly check with our wills team and see if it applies, and very happy to post a response through Kate. I think it applies to anyone, but I wouldn't quote me on that. So moving on to trusts. The very basic question is, what is a trust? They came into existence in the Crusades. The whole purpose was, your crusading noble, whoever it was going to go off to the Holy Lands and fight his battle, but he had his castle, he had his lands, he needed someone to look after them whilst he was away. So he would give the lands to, a sibling, a peasant, whoever it might be, on trust to be looked after while he is away. A trust is kind of like a contract. It's me saying to the trustees, here's my assets, this is how you are going to use them. You can set up a trust under your will. You can set up in your lifetime. It's very flexible in terms of that. But the will trusts and lifetime trusts effectively are exactly the same. The only difference with will trusts is they come into effect on your death. They don't exist before you die, and your will is the trust deed. A lifetime one, you actually have a trust deed drawn up and say, right, I'm putting some money, some asset into that now in my lifetime, and it exists from the moment you set it up. The way a trust works is it's a sort of split of the legal ownership of an asset, whose name is on the tin, whose name is registered on the bank account or registered at the land registry. Those are the legal owners, the trustees, and the beneficial ownership, and those are the people who are entitled to the value of the asset underneath. So a really basic example is a bank account for your child. So your name is on the bank account. You're the one who can go into the bank and say, I want to take the money out, I want to put some money in, I want to change accounts. But the person who's entitled to that money to spend it is the beneficiary, is your child. So it's really important to have that distinction in mind. Say that the trustees, that they can decide how the trust assets are used. You know, are they going to take the money out of a bank account and invest it in a property or in shares or something like that? Always responsible to the beneficiaries. They're accountable to them. So if a trustee makes a mistake, then a beneficiary can turn around and say, you've caused loss to the trust fund. You are personally liable to recompense me for that loss. Now, a beneficiary may not be absolutely entitled to the money under the trust. There are different types of trust interest. Now, you may hear all sorts of different terms for trusts: pension trust, discretionary trust, spousal bypass trust, life insurance trust, will trusts, disabled persons trust. There are a whole host of names. There really are. But at the end of the day, trusts boil down to only three types of interest. You've got a bare trust interest, and that's where the beneficiary is entitled to the assets. It just has a different name on the tin. For tax purposes, for benefits purposes, for all other purposes, the money in that account or the house or whatever it is belongs to that beneficiary. At any point, they can turn around to the trustees and say, give me the legal title. I now want to kind of own it in my own right. At the other end of the scale, you've got a discretionary trust. And that's where you will have the trustees, and you'll usually have a list of beneficiaries. And that could be specific people. It's Bob, James, Alice, whoever it might be, or it might be my children, my grandchildren, my nephews, my nieces, my spouse. It might be fairly generic. None of the beneficiaries under a discretionary trust have any entitlement whatsoever. They only have a hope that the trustees will choose to give them something out of the trust in the future, whether that's an income entitlement or whether it's a capital or something like that. They cannot bang on the trustees' doors and say, hand that money over. They can only just hope that the trustees will do so. And then you've kind of got a middle of the road. That's the life interest trust. And that's where you have one beneficiary, or one more beneficiaries, who are entitled to the income from the trust asset. So if it's a bank account, if it's an investment fund, they're entitled to the dividends or the interest on the account. Or if it's a house, they're entitled to live in that house during, well, I was going to say during their lifetime, but actually it's for whatever period the trust deed allows them. So you can find a trust deed that says, I give my spouse a life interest in the property. They can live in it until they die, or until they get remarried, or until they move into care, or something like that. So a life interest can be for a set period. It can be conditional, let's say, on various events, or it could be for 2 years or 5 years, whatever it might be. And you've then got the remainder beneficiaries. Now, they are the people who are entitled to the asset when that life interest comes to an end. So a common structure I see under wills, particularly with step families, is where we say, yeah, my spouse can live in the property for the rest of their life. They can enjoy the income from my estate. But as soon as they die, or as soon as they get remarried, it goes to the children. So that's a way of kind of guaranteeing, it doesn't matter what the spouse does in their lifetime, your assets will come back to your children at the end of the day. There are all sorts of advantages to trusts. So I'm only looking now at life interest and discretionary trust. I'm not looking at the bare trust interest. As a bare trust, tax, benefits, etc., belong to the individual. Life interest, a right to income, but no right to capital. Discretionary trust, no right to capital or income. So why is that an advantage? Well, it gives you the ability to control what happens to those assets in the trust, either during your lifetime or after you've gone, for a beneficiary who may lack mental capacity, or they may just be a spendthrift, or you may be worried about the influence of a boyfriend, girlfriend, spouse, or some third party who may be after that beneficiary's money. The trustees can say, we're not handing over the money to you. We don't like where your life is going. We may give you an income. We may decide to pay your rent. We may pay off some debts, but you're not getting your hands on this money until we're satisfied that you're financially responsible. You're not under the influence of this third party. So if it's for mental incapacity, that trust can last the rest of their life with the trustees looking after the money for them. Because the beneficiary isn't entitled to the assets under a life interest discretionary trust, those assets aren't taken into account for care home fee funding or for state benefits. It's a really useful way of preserving that money and preserving benefits as well. It's not deprivation of capital for the beneficiary. So it's not that the beneficiary is giving their money away. It's that you've chosen not to give it to them in the first place. And I say this is where deeds of variation under wills don't work, because if you give them the money and they choose to set up a trust, that is them choosing to give the money away under variation. Whereas if your will says it goes straight into trust, it never becomes theirs. Therefore, their benefits aren't affected. And similarly, that's how it protects against claims for bankruptcy and potentially divorce as well. I say potentially, the family courts are, much to the disappointment of private client lawyers myself, they do tend to look behind trusts. And if you have a trust arrangement where really, whenever the beneficiary says, I need some money, the trustees hand it over to them, the family courts may say, actually, that in effect, that trust belongs to the surviving spouse. We will take that money into account. But it adds a layer of protection, and that's where you need really good trustees knowing what they're doing and how to run the trust properly. I say it makes it very flexible. You don't have to decide before you die how much money to give to the beneficiaries. You can leave a letter of wishes that says to your trustees, this is what I'd like you to do. I'd like my son to have half the estate, or I'd like them to have the rent paid for the rest of their life. But at the end of the day, it's up to you, trustees. You decide what to do, what's the right thing to do. Which is why when you're picking the trustees, the clue is in the name. It's someone you trust. Quite as simple as that, really. Someone who will do the right thing. The other advantage is there's no court deputy needed. Now, I'll be talking tomorrow about powers of attorney and deputyship and so forth, but just touching on that now. Where an individual lacks mental capacity and they own their own assets, someone needs authority to look after those assets for them. And that, if they haven't got an attorney, that's going to be a court-appointed deputy. The advantage of the trust structure is you're giving assets to the trustees and saying, you look after them for the disabled individual. And they don't need to go to court and get a deputy because the assets don't belong to that individual. So you can have huge advantages there of not having to go through the whole court application process to get a deputy involved. There is no such thing as a free lunch. There are disadvantages to trusts. They must be run properly. Your trustees need to know what the terms of the trust say. And very, very often I get trustees coming to me because mum or dad set up a will 10, 15, 20 years ago, and the assumption was that assets pass outright to the survivor, or the assets are being used for the children, and actually they've got it wrong. The terms of the trust don't say that. And as I say, I do spend a lot of time kind of fixing problems where trustees have got it wrong. So make sure they know what the terms of the trust are and they're complying with those terms. They should meet. Now, trustee meetings can be done online, it can be done by email, to be honest, but they should be showing that they are looking at the terms of the trust, looking at the beneficiary circumstances and deciding what to do, documenting their decision, saying, we've looked at the beneficiary circumstances, we've decided it's not right to give them income this year, and this is why. Or, they're wanting to buy a house, we're going to loan money from the trust to do so, or something like that. It's got to be documented. Trusts have to file their own tax returns. They need to register with HMRC's Trust Registration Service, unless it's a disabled person's trust. I'll talk about that. So the trust has got to comply with that. And if you're late filing a tax return, you don't pay the tax, there are penalties to pay. You've also got to think about potential conflict. If a trustee is also a beneficiary or a spouse of a beneficiary, they've really got to think about their personal role, whether they really can act independently for the trustees. Should you have a professional trustee? Totally up to you. There's no obligation to have a professional trustee. If you go to someone who makes your will and says, oh, you have to have our organisation as an executor, as a trustee, no, you don't. You have free choices to who your trustees are. It can be helpful to have a professional to have that independent judgment, that independent view, so that it avoids family conflict. It's not essential. And cost. You may well incur professionals' fees for legal fees for interpreting the trust or documenting trustee decisions, preparing additional deeds, that sort of thing. There may be accountants' fees for preparing tax returns and so forth. So say, it's fine to have a trust. They do have all those advantages, protecting assets, flexibility, and so forth. But do think about the administrative side of it, the disadvantages as well. Now, I said I'd touch on tax for trusts. Tax on trusts is probably more complicated than tax on estates, so bear with me. I think it's fair to say, from a tax point of view, government hates trusts, and they prove that by the way they tax them. So the starting point for a life interest or for a discretionary trust, income tax 45% or 39.35 for dividends. But where you have a vulnerable or disabled beneficiary, you can make an election, what's called a vulnerable beneficiary election. So actually the income tax is taxed as the beneficiary's rate, not the headline 45% for trusts, but the beneficiary's actual tax rate, 0 or 20%, depending on whether they're a zero or basic rate taxpayer. Capital gains tax, trustees only get half the annual allowance. I mean, the annual allowance isn't particularly generous anyway. It's only £3,000 now, but trustees only get £1,500, and they pay the higher 24% tax rate. But again, if you have a disabled or vulnerable beneficiary, and when I talk about vulnerable beneficiary, I'm talking about a minor who's lost a parent, then you can make the same election and basically say the trust gains are taxed as belonging to the beneficiary. So it's their rates that apply, full annual allowance and potentially lower capital gains rate. Inheritance tax, and this will sometimes raises eyebrows with people because they say, well, inheritance tax is a death tax, surely. It's not only a death tax. Trusts suffer inheritance tax when you put money into them and when you take money out of them, and every 10 years. But if you have a disabled beneficiary, and when I say a disabled beneficiary, that's someone who is in receipt of PIP or DLA or certain other benefits, or is mentally incapable of managing their finances, then the terms of the trust are very specific, and I'll talk about what they are in a second. Then the revenue say, okay, for inheritance tax purposes, we'll treat the capital value of the trust fund as belonging to the individual, so it's not taxed until they die. And there you're looking at that 40% rate and nil rate bands and things I talked about earlier. If, on the other hand, you just go with a life interest trust or a fully discretionary trust, as I say, you are looking at that 6% charge every 10 years and when assets taken out and so forth. So it's really important when setting up a lifetime trust to think, actually, what's the value I'm putting in? Is there going to be a tax charge straight away? I realised actually what I haven't mentioned on there, there's actually a 20% tax charge when you put assets into a trust. So say trusts are a good way of protecting assets, but you do need to think about tax implications. But if it's a disabled beneficiary, then actually you can have a trust with no negative tax implications. It's treated for tax purposes as if you've given the assets to them outright. The disabled person's trust or disabled person's interest to trust, the requirements are, as I say, the main beneficiary is a disabled person, someone in receipt of DLA, PIP, or mentally incapable of managing their own finances due to lack of capacity. And the trust terms the contract provides that during the disabled person's life, the trust can only be used for their benefit. So the idea is you put the money in the trust, no one else can get money out of it, or the money can't be used for the benefit of anyone else except for the disabled person. And say, if you tick that criteria, or those criteria, then for inheritance tax purposes, it's as if it belonged to the disabled person. To get the income tax and capital gains tax beneficial treatment, the main beneficiary must be a vulnerable person, so that's someone who is either a disabled person or a child who's lost a parent. And again, the trust terms provide that during the lifetime of the vulnerable person, the trust can only be used for their benefit. then income and capital gains, it's treated as belonging to the vulnerable person. So to say that whilst the government hates trusts, it recognises there is an absolute appropriate role for them with vulnerable and disabled individuals. What should you do? Should you do a lifetime trust? So as I talked about, you could set up a trust under your will. So you've got your assets in your estate, your property, your bank account, your shares, your savings, whatever it might be, can pass under your will into a trust created by your will. But that doesn't cover pension lump sums, death in service, gifts from third parties, and so forth. So one way you could, or something you can do, is set up a lifetime trust for your disabled child, and say, right, effectively treat it like a bucket, if you like. Here's my lifetime trust. Here's the bucket. I'm putting 10 quid in there. I'm the trustee. You pick whoever you want as trustees, but the idea is the money in this trust can only be used for the benefit of my child during their lifetime. That then sits there ready to receive money from your pension service. So you write to your pension company and say, I'm changing my nomination. I want you to pay the money into this trust after I've gone. Similarly with death in service or life insurance, you can nominate it to that trust. If you've got friends or family members or other people wanting to benefit your child, you say, look, don't give it to them outright. If you give it to them outright under your will or make outright gifts to them, benefits disappear, or we might start needing an attorney or deputy to manage that money. Pay it to this trust, please. So a lifetime trust has exactly the same tax implications we were talking about before, and it may well avoid the need for a deputyship. So a lifetime trust might be quite a useful thing to do. And then you don't need a complicated will either. You base in your will, you say, right, I'm leaving my estate to this trust. And it's there and it just carries on running. And it can be dormant during your lifetime. So you put £10 in it, it just sits there waiting to receive assets from elsewhere. If it qualifies as a disabled person's trust, there's no need to register it with HMRC unless there's income tax payments and capital gains tax and so forth. But otherwise, it could just sit there dormant, and there's no need to interact with HMRC on it. The key thing I would say about trust is, for goodness sake, do it properly. Make sure you're getting advice from a properly qualified professional. I would say, if you are seeking advice on this, go to a STEP member. That's the Society of Trusts and Estate Practitioners. We take a lot of exams and do a lot of training to make sure we know what we're doing. There's so many people out there saying, oh, do a trust, it's going to be brilliant, without thinking about tax implications, without thinking about the correct wording. And so many times I find little typos in trusts can cause big problems later on. Trustees got to make sure they exercise their trust powers properly, so they record it, they document it properly, they've got to comply with their duties, they've got to remember the beneficiaries come first, they are personally responsible to those beneficiaries, they've got to do their tax reporting and accounts, which I talked about before. So trusts are a really useful tool, lifetime and or under your will, to really protect assets for the long term for your disabled children. You know who's looking after them. They can use that money to pay for additional care or purchase them a property or give them an income out of that trust fund without it falling into the child's hands, without it being assessed for benefits purposes. I'm conscious with about 10 minutes or so left. I'd just like to wrap up with the promised case study. There we go. So we have Mr. and Mrs. Scratchit. I'm a Blackadder fan, hence the Scratchit reference. So we've got Mr. Scratchit. He owns his half share of the property, about 100,000. He's got savings about 150 and a pension pot of about 250. Mrs. Scratchit, she owns the other half of the property, 100,000. She's got her own savings of 50,000 and a pension pot worth 75. They've not made any nominations in respect to their pensions, so likelihood is the pension company's going to look at simply who's entitled under the intestacy rules on death. And so we're looking at 3 children, Bob's 16, Harry's 21, and Pad's 25. Now, Bob's in full-time education. He's got special educational needs. Harry suffered a brain injury as a child. He's mentally incapable of managing his finances and probably will never be able to do so. Pat, on the other hand, successful business owner. She's doing very well for herself. So let's look at what happens when they do it the wrong way. They don't make wills. Mr. Scratchit and Mrs. Scratchit both fall very ill. He dies first, and very shortly afterwards, Mrs. Scratchit dies as well. Mrs. Scratchit's estate doesn't inherit anything from Mr. Scratchit's estate, because to inherit under intestacy, the survivor must survive 28 days. That means Mr. Scratchit's estate, which is worth more than his nil rate allowances, has to pay inheritance tax of about £30,000 on his death. It goes straight through his estate down to the children, £30,000 of inheritance tax. Mrs. Scratch's estate, that's within her nil rate band, no tax to pay. But the problem is between them, they had £1 million allowance. Unfortunately, they haven't used it properly by not making their wills. Basically, the rest of the estate passed equally to the children. It was about £230,000 for each child. So with Bob, what happens to him? Well, his condition isn't too bad. He's able at the age of 18 to live independently and manage his finances, but he's young. He doesn't see the benefit of property ownership. He just wants to rent with his mates. He's easily influenced though, and he is vulnerable to financial abuse. He meets a girl, they start to rent a property together. She persuades him to buy lots of lavish gifts and pay for expensive holidays. He's got £230,000 gold mine there. He spends it all. He eventually has to move into state-funded accommodation. She sees the money's runs out, so leaves him, and he ends up as a lonely bachelor. Not so good for Bob. Harry, well, he has care needs, but they aren't sufficient to qualify for free NHS funding. But he now owns more than £23,250, so the local authority provide no financial assistance towards his care costs. He can't manage his finances, as he lacks capacity. Pat's too busy to do it. Bob's probably not an appropriate person to do so either. So the local authority applied to be his deputy. They manage his money, and they just use it to pay his care fees. That runs out, and then the local authority fund his care personally. So he's kind of stuck in local authority accommodation without a fund to rely upon. Pat, well, she uses the money to pay off her mortgage, invest the balance, but her business was suffering before her parents died. She uses some of the money to prop it up, but it still fails, and she files for bankruptcy to sell her property, to settle the business debts, and there's little money left, so ends up being employed. So a bit of a disaster all three ways. And I say that they aren't real life examples, but they are things taken from real life client examples. So what happens if they do it right? Well, this time, Mr. and Mrs. Scratchit do make wills. They leave their estates outright to each other, and then on the second death into a discretionary trust. And if you remember, that's the structure I said where the children are not entitled to anything outright from the trust. It's up to the trustees to decide how to or what to give them. So they appoint Pat with a professional executive professional trustee, and they leave letters of wishes, guidance to the trustees saying, please give a third or use a third of the fund for Bob's benefit until he's financially mature, then give it to him. A third of the trust fund should be used to help Harry with his care needs, and the remaining third can be given to Pat outright if she wants it. So what's the difference? Well, with Bob, again, as I say, his condition's not too bad. He can live independently. He's still young. He wants to rent with his mates. So the trust say, okay, we will invest the trust fund and help pay your rent. He meets the girl again. She tries to encourage him to buy expensive gifts, but the trustees say, no, we are limiting your access to this capital fund. We're not giving you anything outright. We'll give you an income. And she loses interest because he's not the gold mine she thought he would be. He then meets Wendy. They set up together, and she helps him manage his finance, and the trustees go, great. You know, he's looking sensible, he's looking appropriate. And the trustees themselves answering that question there, it's the trustees who decide that he's financially mature. You know, he's not at risk of being influenced by third parties. He seems to be sensible. We, the trustees, are now handing the money over to him, invested in a property, and they live happily ever after together. What about Harry? Well, let's say he doesn't get NHS funding, but this time he doesn't own more than £23,000. The money is in a trust, it's not his. So the local authority do provide financial assistance with his care costs. The money's in a trust, so he doesn't need the local authority to be a deputy. The trustees are looking after this. And they say, well, actually, he could do with specially adapted property, and we'll use some of the money to pay for additional care. So he's still getting the state funding for his basic care needs, but the trustees use the additional funds that they've got, these ring-fenced funds, to help pay for additional equipment, sailing holidays, and so forth for him. There's still a bit of money left in the trust on Harry's death, and that gets added to Pat and Bob's shares. The trustees decide to split it between them. And then finally, Pat, well, she knows her business in jeopardy. She says to her co-trustee, look, can I have some money? I need to prop it up. The trustees take advice, and actually her business isn't doing well. It's too risky to put the money in. So sadly, she still has to file for bankruptcy and still loses her house. But the assets in the trust are not taken into account. The trust lends Pat some money. She starts a new business. She's a sensible person. It does very well, and she becomes wealthy in her own right. She repays the loan to the trust, and the money's sitting in there now. She said, actually, I don't need it. If I get it, I've got an inheritance tax problem. Give that money directly to my children. It's not a gift by her. It's come directly from the trust. So it's a useful way of ring fencing assets for all three of those children, meaning they've got state assistance when they need it. They've got someone looking after the money, ensuring it's being looked after responsibly for them, and it's helping ring fence money from bankruptcy. Hopefully that brings that all a bit to life. I think some final hints and tips. Check what you own. Dig out pension policies, dig out life insurance, check your death in service, make sure you know who gets what on your death. Look at what actually passes under your will and what doesn't, so check the ownership of assets, joint tenants or tenants in common. Check or make your will. I'm not going to do a poll of saying how many people haven't made a will. Normally 50% of our people put their hands up. So yeah, if you haven't got a will, you've got a disabled child, or if you're unmarried, put one in place. It's really important. Consider a lifetime trust. That's important if you've got funds coming from pensions or insurance or third parties. Have that bucket ready to receive that money. Speak to friends and family about how you want to structure things for your children, and say, I've set this trust up. Please put the money into that. And say, check your nominations for pension. Make your wishes clear. And I really recommend attending tomorrow's webinar on lasting powers of attorney, because I'm going to talk more about deputyships and so forth there, building on what we've already talked about.